Well, welcome to Polity Matters. Ben is out today, and so I'm going to be attempting to lead this discussion on Chapter 43 of the BCO on complaints. But we do have some help that is with us, a man named Art Sartorius, and I wanted to ask you if you can introduce yourself and why we might have asked you, maybe even getting into a little bit of your various questionable vocations in the past. So who do we have joining us, Scott and me today?
This is Art Sartorius, as you said, and I was described by you as being help. I'm not so sure if that's an accurate description, but I am a PCA teaching elder out in Rapid City, South Dakota, so the uttermost parts of the world. And I have been a teaching elder I guess since 2008. Before that, I was a ruling elder. And when I was a ruling elder, I had been a lawyer. So that's sort of my background. The topic we deal with, complaints, I guess my experience with complaints began pretty early on. Once I became a teaching elder, I think it was the first meeting I attended as a presbyter here in the Siouxlands Presbytery. A man was asked to be investigated regarding his views. And then right after that motion was made, complaints started arising. And through that whole process, there were several complaints along the line. Since that time, things have settled down. And I am now a member of the SJC, so I now see complaints from the other side too. So that's who I am. That's some of my background. I hope it's helpful.
Yes. And did you have some training as a journalist too?
Well, I have a degree in journalism. I worked on a local small paper for about a year. And it wasn't long after that I went to law school. So not much. Yeah, not much of a career as a journalist.
Are you gonna try selling used cars anytime soon, Art?
No, but I did just buy a used car. Would you like to buy it?
Yes. So you get the trifecta of most beloved career paths.
That's right. That's right.
All right. Well, we're gonna just launch into complaints. We've already covered to some degree appeals and the other chapters leading up to 43. So we're just going to have you help us a little bit on this chapter. We can make some comments too. Scott and I have at least read this chapter at some point in our lives. But we're starting off with the definition of it here in 43:1, and this may take a lot of our time. This is where Ramsey and Smith actually have some things to say. But 43:1 reads as follows: a complaint is a written representation made against some act or decision of a court of the church. It is the right of any commuting member of the church in good standing to make complaint against any action of a court to whose jurisdiction he is subject, except that no complaint is allowable in a judicial case after process has commenced. If at any time after the process has commenced, a BCO 43:1 complaint is timely filed, the court's adjudication shall be delayed until after the judicial case has been completed, or if an appeal is filed, after it has been fully adjudicated or withdrawn. During judicial process, the accused may raise BCO 32:14 objections on a variety of matters, and the original court shall decide each. Those decisions could be reviewable on appeal. So perhaps our first question is going to be, appeals seem to narrowly deal with judicial matters. What does a complaint deal with? What is subject to complaint?
Well, really the subject matter of complaints is extremely wide, and I would even say it can include at times things that could be subject to appeal as well. So for example, if if a person has been accused, he's gone through judicial process, he's been found guilty, it could even be possible, perhaps, that another member of his church or another member of a presbytery could complain against the guilty verdict if he doesn't appeal it himself. If the appeal has been done, which most likely would happen if it's going to go that far, you don't see that, but you do see instances where someone has been acquitted and members of the court will then complain against the acquittal. So that could be it. We've dealt with things on the SGC in which you're actually dealing with a matter which what has been complained about is the moderator's ruling on a point of order that is then upheld or not upheld by the presbytery. So it could be as limited as that. You can even start imagining things, and conceivably, if a church decided we want to have a church picnic on a certain day, someone could complain against that because that is decided by an act or decision of the session. Again, those aren't things you normally would see. Hopefully you wouldn't see, but it could be pretty broad.
Yeah, I mean, an act or decision seems to entail almost anything that the church court is doing. But also thinking about if somebody is dealing with this in a church court, if somebody's listening to this because they're dealing with a complaint, what's the basis of a complaint? It seems like something unbiblical has happened against the standards. But is there a limiting factor? I mean, can you just say, I don't, you decided on this carpet color, you don't realize that it contrasted poorly with the pulpit, and so I'm going to complain. Is there any limiting factor on the basis for doing a complaint?
Well, I would say if you're looking at the language there at the beginning, there's not really too much limiting there as far as that's concerned. There are limitations. The person has to be a communing member of a church. He has to be in good standing in the church. He has to be under under the jurisdiction of the church, either the church court or the presbytery, which then that is probably the single most limiting factor you have. When you start thinking about who's under the jurisdiction of a court, well, that would mean as members of a presbytery, you really can't complain against decisions of another presbytery because you're not directly under that court's jurisdiction. The other matter, I think, becomes a little more complicated because when you read that first language, a complaint, the second sentence of that, the first paragraph there, it is the right of any communing member. That sounds extremely broad. And yet, when you start thinking about jurisdiction, the rulings that have come out of the SJC have limited jurisdiction so that, for example, if I'm a member of a church, I can't make a direct complaint against the action of a presbytery because I'm not directly under their jurisdiction. Although they are making decisions that affect my church, I don't have a direct right to appeal. That's based on the various decisions of the SJC in the past. Someone could still challenge that, but that's generally what it would be. Let me give you an example. If the presbytery license someone to preach within the bounds of the presbytery, that affects the local church. But a person in the local church, a person who's not an officer, just a member of the church, would not have that direct line of appeal to, or rather complaint against the licensure.
Scott, do you have something?
Yeah, as I was reading, as you read this, Jared, this is actually a newly minted paragraph. It's been doubled in size by the last GA. as it relates to that second part that you read on interlocutory appeals, that is, complaints in the midst of appeal processes. And one thing that our last assembly decided would be prudent is instead of allowing complaints to be handled in the midst of judicial process, that they're kind of set aside until the process is complete and then taken up together. And I think at least if I recall, the rationale for adding this paragraph into 43.1 was the abuse of complaints as it relates to judicial process, where an accused might complain about every little action that the court does in order to slow down the trial itself and span it out for, it could be up to years, as we've seen in some cases. And so this is meant to perhaps expedite, as we can in Presbyterianism, expedite appeals and complaints by almost setting them aside for a time until the appeal is completed and all process is concluded.
Yeah, I'd also encourage anybody, if you can get onto the BCO historical site or get a copy of Morton Smith's commentary. He has a lot of qualifications on here, the differences between appeals and complaints. And some of those limiting factors are interesting during a judicial process, if you're not subject to it. There's also an interesting inquiry that came into CCB at one point, and it was a question about congregational meetings, because those are not technically a court of the church. Well, the response was you can't really complain against a congregational meeting, but you can complain against the session about whether or not they should have had that congregational meeting, whether they should have put that question before the congregation, and how they acted in response to whatever they heard from the congregational meeting. So in a sense, you can't complain against your congregational meeting, but you can complain against the session that made it. So anything else we need to say about 43.1?
I just might follow up in regard to that point. One thing that happened in some recent, now completed SJC cases, there was a congregational meeting in which men were elected to church office, ruling elders or deacons. That action was complained against, and as you said, because the congregational meeting is not an action of a court, that was the complaint was denied. But then when those officers were installed, it was the act of installing them that became subject to complaint, and that complaint was heard.
One other question, I don't know if you'll know the answer to this. It made me wonder, especially with our distinctions between assistant, associate, and senior pastor. Can any of the teaching elders complain against an action of the session, since in some ways they're not under its jurisdiction, but they might be a member of session, or they might not be as an assistant?
Yeah, well, ruling, I would think, I'm trying to imagine a situation that the ruling elders, of course, are members of the church. Mm-hmm. So they could complain against the action of a session, I would think, yes.
What about the teaching elders?
Teaching elders are members of the presbytery, so they don't have a right to complain against the actions of the session.
All right. Well, moving on then to it seems like the rest of the chapter really is defining things from there. So 43.2 is going to, and 43.3 really are going to get into timing and some of those details. So let me just read 43.2 and see what we have to say on this. A complaint shall first be made to the court whose act or decision is alleged to be in error. Written notice of complaint with supporting reasons shall be filed with the clerk of the court within 60 days following the meeting of the court. The court shall consider the complaint at its next stated meeting or at a called meeting prior to its next stated meeting, provided that the complaint has been filed with the clerk at least 10 days in advance. If the complaint is filed with less than 10 days notice, the court may consider the complaint at a later meeting, not more than 60 days later. No attempt should be made to circularize the court to which complaint is being made by either party. So what are we getting here? Why is a complaint first made to the court whose act or decision somebody has a problem with?
Well, I think that's one of the best sections. That's one of the best portions of the complaint, because what you're doing is giving the court a chance to correct an error if they thought they made an error. It's a gracious thing to do, to just say, hey, I think you did something wrong here. They can rethink it and they can correct their own error, recognizing that courts can err. And so that's a marvelous provision. I think that's wonderful that the session or a presbytery is given that opportunity before a case is moved to the presbytery or the General Assembly. Give them an opportunity to correct the wrong if you think they've made a wrong.
Mm-hmm.
Doesn't mean they always think they made a wrong, but
yeah. But it does cut down on paperwork if the court just says, oops, sorry, or if the complainant is then convinced by more reasoning.
Yeah.
We do have a time limit, 60 days. Feels like this is a bit arbitrary. You kind of have to pick a date if you're not going to say you can complain about something that happened 5, 10, 15 years ago. So there is a time limit that's there. And then you have to meet after that complaint has been noticed. So maybe your timing of filing a complaint would be so that you don't have to have another called meeting, but you're either going to have to have a called meeting or a stated meeting. And then you have to reconsider basically what you did in the previous time together. So some of those are making sure that you're in that window there. But the ending of that is interesting. I don't know if you can give us some help on what it means. No attempt should be made to circularize the court to which the complaint is being made by either party. What does that mean?
Let me say first, since I am a member of the SJC, that I'm not making any statements with any view toward a pending or impending case on the SJC. And I probably, even as I say that, probably won't answer this maybe as directly as I might personally feel. But the idea of circularization, I actually first even explored that when I was first dealing with filing a complaint and was trying to figure out, well, what in the world does circularizing mean? And, you know, if you look at various definitions, sometimes there's been one definition could be going around, which almost seems like, oh, you're trying to go to the next higher court as opposed to having it before the court you should be. But the general proposition as it's developed over the years is that you're not circularizing as if you're sending circulars to members of a court to persuade them how they should vote before the members are gathered together to vote on the matter. And you can see how that happens. You know, if I want to file a complaint, yeah, I might be inclined without this rule to go to other presbyters and just say, hey, I think this has merit. I want you to consider it. Will you please join me in this? Will you vote the way I like? Would you like to hear more arguments on it? And the sentiment is no, you shouldn't be able to do that. I would say that there have been some past cases that deal with the idea of this isn't really meant to hinder individual presbyters from having small conversations with others in their presbytery, or you could think of it on a church session as well, other elders. Just a few conversations about what this is all about, what we ought to be thinking about, what we should do. I think the most interesting part of the section though that says you should not make attempts to circularize is it says at the end, it's not to be done by either party. Well, if you think about who are the parties, and I'll focus in on the question of a presbytery, who are the parties to that? One of the parties is, of course, the complainant or plural complainants. The other one would be the presbytery. How does a court circularize itself? So, and that's a question I don't want to try to answer for you all. But it's an interesting question, at least in my mind.
Yeah, we
Agreed?
talked a little. We talked a little about circularization last week with Dr. Waters, and it's interesting how, in my experience in Presbytery, it's the definition is somewhat fluid. It's like a scary word. We want to avoid circularization. And sometimes it's even said on the floor of Presbytery, like at a meeting, you can circularize yourself on the debate floor, but that's not really the context. Like you're not circularizing yourself by debating an issue. It's what goes on outside of the meeting and how parties conduct themselves on any given issue, whether it be something small like where we're holding our retreat for our youth camp. One caucus wants it here, another one wants it there. But it's outside of the meeting where you're trying to garner support, caucusing for a position before you ever have the debate.
Yeah, because you have to talk to some people, probably even within your presbytery. If something happened, you're probably going to call up somebody and be like, "Hey, do you think this is worth a complaint? And if I did that, would you join me on it?" If there's more than one complainant, he's talked to somebody, so that can't be circularizing. So we're thinking this is probably like caucusing or campaigning. We're trying to have the argument before everybody in the presbytery can hear it. Yeah. All right. Can we go on to part 3 and try to figure out more on timing? The dates. That's the most fun part of the BCO, right? The timing. 43.3. If, after considering a complaint, the court alleged to be delinquent or in error is of the opinion that it has not erred and denies the complainant may take that complaint to the next higher court. If the lower court fails to consider the complaint against it or at its next stated meeting, provided that the complaint has been filed with the clerk within at least 10 days in advance, the complainant may take that complaint to the next higher court. If the complaint is filed with less than 10 days notice, the court may consider the complaint at the later meeting, not more than 60 days later. Written notice thereof shall be filed with both the clerk of the lower court and the clerk of the higher court within 30 days of notification of the last court's decision. Notification of the last court's decision shall be deemed to have occurred on the day of the mailing, if certified, registered, or express mail of a National Postal Service or any private service where verifying receipt is utilized, the day of hand delivery, or the day of confirmed receipt in the case of email or facsimile. Furthermore, compliance with such requirements shall be deemed to have been fulfilled if a party cannot be located after diligent inquiry or if a party refuses to accept delivery. So, notification. This is, I almost want to use the language of appeal to the next higher court, but this technically is an appeal. You're just taking your complaint to a higher court if you don't like what the lower court said, or the lower court brushes you off, refuses to hear it, something along those lines. Is that fair to say what this is saying to us?
Yes, it is whatever it is elevating to the next higher court. The changes that have been made to this over the years, I'll just go back again to a time when I first filed a complaint. I always filed the complaints using Federal Express next day delivery, because you didn't have specifications like, does it count as being delivered when you put it in the mailbox, when it's received? How is that? And so it was just a way that it would confirm that it was received, would confirm that it was mailed by a certain time. You had all of that done. Here you've actually put that in, and I think if I remember right, when these were first being considered of matters of deeming giving notification, that the words United States Postal Service were used.
Mm.
And someone from Canada wisely said, do you remember you have Canadian people in the PCA as well? And so, so the language has been changed. The other thing that I think is sort of interesting in this is that you have the idea of notification of the last court's decision shall be deemed to have occurred on the day of mailing. Well, it could be it could be that there's actual notice given, instead of even communicating by mail or email or any of the things that are given. It could be just, here it is, here's my complaint, given by hand. The last court's decision is terminology that, when do you get the last court's decision also? There have been times when courts have adjudicated things and for what they deem to be prudent reasons decide not to give notification of their decision immediately. They want to talk to lawyers, they want to do other things, they withhold it for a time. So it's that idea of actually giving the notification of the decision is an important factor.
It seems
There
so
are times
like,
when, sorry.
yeah, it seems like a no-brainer until you start thinking about the details. And that's kind of church process in general. It seems really simple, and then you start thinking of the details and like time frames, and they're very important. All the time frames are excruciating when you're doing a trial, and the BCO doesn't always give you specifics, but here it does. And you wouldn't think about it until you have to actually send out your complaint. When does it matter? And so this is helpful. Though it may seem really simple and, like a no-brainer, it's helpful to have these clarifications.
Yeah, and another clarification is there in 4, because if you remember on appeals, an appeal in many aspects suspends what had been the action of the court. Well, this specifies something a little different. 43.4 for a complaint. Notice of complaint shall not have the effect of suspending the action against which the complaint is made, unless 1/3 of the members present when the action was taken shall vote for its suspension until the final decision in the higher court. So this is saying if there's a decision and you're complaining against it, it doesn't mean that that decision isn't going to go through unless you get 1/3 of the people that were there to vote for it. I do have them in my mind. When would that 1/3 vote to suspend that action? Would it be as the complaint is being considered? If you have a notice of complaint at that meeting, maybe 1/3 would say, okay, let's suspend this until we hear the complaint. That would be the only detail that has a question mark in my mind there.
It also might be interesting to note that some decisions can be made by commission as opposed to the full court. Is the 1/3 of the commission? I mean, those are probably not common things. I don't recall ever seeing something like that come up, but potentially you could have something like that.
Mm-hmm. Anything else we need to straighten out on 4? Otherwise, you can go to 5, which really gets into the details of how the complaint is actually argued. 34 or 43, 5. The court against which complaint is made shall appoint one or more representatives to defend its action before the higher court, and the parties in the case shall be known as complainant and respondent. The complainant himself may present his complaint, or he may obtain the assistance of a communing member of the church, Presbyterian Church in America, who is in good standing in presenting his complaint. So the court, when a higher court is considering this, it's not as if the entire church and session have to show up to presbytery when this goes to a higher level. You can have one representative of one side, one representative of another side that comes and presents. Anything else that we need to know about this provision here?
I think it's this has been another section that's been changed a little bit where it broadens the representation of who you could get. It's not just someone from your church, someone from your presbytery. It can be anyone in the PCA. So it's a benefit there to potential complainants to seek help from other sources and representation.
Yeah. While you don't want it to be too far and for there to be some sort of class of lawyers, no offense to lawyers, that arises in the PCA, you do want somebody to not fail in something just because they didn't know the process or didn't know the rules. And so clerks have this job too to be informing everybody involved of what comes next, what their rights are. Yeah. All right, 43.6. It shall be the duty of the clerk of the lower court to file with the presbytery of the higher court, or the clerk of the higher court, not more than 30 days after the receipt of notice of complaint, a copy of all its proceedings in connection with the complaint, including the notice of complaint and supporting reasons, the response of the lower court, if any, and any papers bearing on the complaint. If the clerk of the lower court shall neglect to send up the proceedings on the complaint, he shall receive a proper rebuke from the higher court, and the act or decision complained against shall be suspended until the proceedings are produced, so that the higher court can fairly consider the complaint. So make sure you have your paperwork in order. But a couple questions may arise from this. First of all, what is a proper rebuke?
I've seen a rebuke that's arisen from this, and it's I mean it is an expression of dissatisfaction that the deadlines haven't been made,
Mhm.
and pretty strong language. You need to get your ship in order and get it taken care of. I haven't seen it go much further than that, though.
Yeah. But this is another provision in which an action might be suspended. And perhaps that is in there just so that a lower court can't run out the clock of just non-compliance and we'll just let this action happen and then you can't do anything about it later. Because I've seen decisions from the SJC that, in a sense, at a certain point to say there's really nothing that can be done, even if they had done something wrong, because the action is now passed. So this prevents a lower court from trying to just make sure the action happens so that it can't be corrected.
Mm-hmm.
Anything else
And well, I would just say there's nothing wrong with a clerk contacting a higher court and saying, I'm having trouble getting these things all together. I'm not going to make the deadline. I'm striving to get this done and think I'll have it done by then. And then the proper rebuke might not come at all. And I think that's a worthwhile thing. Again, I'll use my presbytery as an example. Say a complaint arises out of an acquittal in a judicial case. That means that you have to have a full transcript of the trial. And the rules that require you to have a transcript, when you have the trial, you only have to have it recorded. So you could have an instance where you need to have a recorded testimony, all of the testimony then transcribed. And when you're working from a recording, that can be a more difficult thing. And so sometimes it takes some time. And I have seen a case like that where the SJC was very, very kind and just said, we understand it takes a while to get that done. We won't have the hearing when we wanted to have it. We'll delay it till a little later time.
All right. A few more parameters are going to be given to us in 43:7, including the concept of abandoning a complaint here. There it reads, the complainant shall be considered to have abandoned his complaint if he fails to appear before the higher court in person or by counsel for a hearing thereof after he has been properly notified. But a complainant may waive in writing his right to appear with permission of the court and not be considered to have abandoned his case. In the case of such failure to appear, the judgment of the lower court will stand unless the complainant gives to the court a prompt and satisfactory explanation. So if you're going to complain, make sure that you're willing to see it out. I do think there's some other ways in which people will have been considered to have abandoned their complaint, such as if they resign from church membership or leave the church or leave the presbytery, which could be probably more often, which is maybe why you would want to have more than one person on a complaint if you're going to complain something and you may not be there to see it through, to get another person or two with you to say, if we all think this is wrong, then can you be on it in case one of us isn't here in a year or whenever it's going to be decided. So anything else we need to say about 30 or 43:7?
There again, it doesn't compel the complainant to appear either. He can waive his right. He just needs to do it in writing. And then the higher court will make their decision based upon one side arguing and whatever's been submitted in writing, the complaint itself or a brief.
Do you often see complaints abandoned at the SJC?
There have been. You have to understand, my tenure on the SJC has not been decades like some of the other men who are on the SJC. So I might not have the best memory of those times that it's happened. I have seen it though, and you've also had the times that Jared was talking about when someone might leave the membership of the PCA and the matter will be deemed abandoned.
Yeah, we were talking with Guy Waters last week about appeals, and it has similar language in the abandonment of an appeal. And you just think of how much work it takes to do some of this. And so I would think that it's quite rare for someone to abandon an appeal with all the work they might put into it, unless they just left altogether.
Well, next provision may not have a whole lot of commentary with it, but we can read it and see what it talks about in timing. 43:8, subject to the provisions below, after the higher court has decided that the notice filed with the clerk was timely and that the complaint is otherwise in order for it to be heard by the higher court, it shall hear the complaint or in accordance with the provision of BCO 15.2 and 15.3, appoint a commission to do so. Ordinarily, the court or its commission shall schedule a hearing in a manner that reasonably accommodates the schedules of the representative parties and affords each party a prior opportunity to file a written brief upon such terms and in accordance with a briefing schedule established by the court or its commission in the reasonable exercise of its discretion. I don't know if there's a whole lot to say about this other than they schedule a time in which is convenient for everybody to make the complaint for them to hear it.
Correct. And most of these now, at least on the SJC level, are done virtually. They're done by Zoom or similar mechanisms that allow us to see each other and do that. They used to be done where you would actually be traveling to a location where everyone who was serving in the SJC, it's a panel that normally hears it and then presents it to the whole of the SJC. But that was that's pretty much ended. There have been a few that still happen that way, but now it's usually all electronic.
Right. And then what does it actually look like is in 43.9, which is a little more interesting. At the hearing, after all the papers bearing on the complaint have been read, the complainant and the respondent will be given the opportunity to present argument, the complainant having the right of opening and closing the argument. After the hearing has been concluded, The court or the commission should go into closed session and discuss and consider the merits of the complaint. The vote shall be then or later be taken as to what disposition should be made of the complaint, and the complainant and respondent notified of the court's decision. So I've seen a few of these in Presbyterian. Sometimes it'll even look almost formal, like you may see a minority report at General Assembly. Almost seems like that. One person goes up and presents, another person does. And then there might be some structure in between that the trying to figure out how much time does each side get? Is there time for questions in between and then closing arguments? So that's what it would look like in that court. Anything else to say on that, such as the nature of closed session or anything like that?
Well, closed session is just the members of the court or the members. It's like executive session, but not exactly the same. But it's just the members that are hearing it, the members of the commission that are hearing it, that are meeting at that time to make their deliberations and make their decision.
Yeah, executive session, you can't talk about what was said there, but closed session, you may be able to talk about the arguments, even if you're not attributing it to a particular person, right?
Yes, correct.
Would there be any reason to reject a complaint out of order outside of maybe the time frame stuff?
Well, time frame is the most common one, of course. And I guess my answer to the question, to answer it directly, is yes. And then if I try to give you examples, I might not come up with any right away. But yeah, I mean, there have been things where, like, it could be apparent in the record of the case that someone has filed a complaint, but they're not a member of the church anymore. They've left the denomination. There can be things like that. So that would be one I can think of. But there are circumstances that, yeah, you would rule it out of order. That's the one that comes to mind, other than timing.
Yeah.
And it doesn't specify when notification happens, but hopefully it is timely. 4310, to finish off, the higher court has power in its discretion to annul the whole or any part of the action of a lower court against which complaint has been made, or to send the matter back to the lower court with instructions for a new hearing. If the higher court rules a lower court erred by not indicting someone, the lower court refers the matter back to the higher court, and the lower court refers the matter back to the higher court. It shall accept the reference if it is a doctrinal case or a case of public scandal. Maybe this reminds us that actually a complaint doesn't mean that there's a whole new trial if it's a judicial matter or something like that. Often it seems like higher courts are just directing the lower courts to do a trial, or you should have done a trial and you didn't, something along those lines. I think the SJC has only really done like one trial or a couple of trials in its entire history. So usually the higher court isn't doing that on appeal from a lower court. Is that right?
Usually not. And I think as far as trials are concerned, the SJC really doesn't want to do that for good reasons, because you have you have a better group to judge matters when they're closer to the facts that are involved. And so in a trial situation, you won't normally see the SJC wanting to get involved. I think what's interesting about 4310, though, when it comes to what it says the higher court can do to annul the whole or part of the action of the lower court, or send the matter back to the lower court with instructions for a new hearing. And there could be issues that arise as to, does the higher court, say the General Assembly or a presbytery dealing with the session, do they go too far if they're doing anything other than annulling the past decision or giving instructions for a new hearing. Like if they give instructions and basically say, this is what you need to do, rather than say, just have a new hearing, are they overstepping their bounds? And so that would be a question. Again, it's not something that I think comes up very often, but there are reasons why you might not. I mean, as far as annulling a decision, I think, Jared, you had mentioned earlier something like with the passage of time, the matter becomes moot. So, you're annulling a past action in which the time is past has made the issue that was dealt with moot. Why would you really annul the past action? You would just say it's no longer relevant. You wouldn't ask them to have a new hearing on something that can't be undone. So it's just, there could be questions there on what the higher court can do, or do they have some inherent power to do something beyond just annulling the whole or ordering a new hearing. And I think the last line, if I'm getting ahead of myself, forgive me, but the last sentence of 4310 is interesting too. If the higher court rules the lower court erred by not indicting someone, and the lower court refers the matter back to the higher court, it shall accept, that is, the higher court shall accept the reference if it's a doctrinal case or a case of public scandal. And there again, I'll just, speaking from the perspective of the SJC trying a case, and again, complaints can lead to retrials of cases. That's not something that the SJC is well equipped to do. If you're going to have a trial before the whole panel, you either have to take, or the whole of the SJC, you have to take the whole of the SJC to the area where the case has all the facts and witnesses, or you have to bring all the witnesses to the SJC, which would probably be in Atlanta. So you're bringing in people from all over the place. And even with a panel, you're doing the same thing. It's a smaller group, but there's a lot of expense involved. And so the mindset, I think, of most on the SJC is we don't want to say somebody's erred by not indicting someone. But then again, you have to understand that shouldn't govern whether you rule the complaint or not. It just might weigh heavier on your mind. What can we do other than send it back and say you failed by not indicting? That could go in the mind. I hope it's not going on in too many minds, but it could.
Yeah, it kind of reminds me just a few years ago with the Heron trial and just all that was included in it, and the cumbersome nature of having a panel be flown out to Indianapolis and to spend the better part of a week conducting it, and then you all on the SJC just receive basically the report. And it's like, how can you really even if there were a minority on the SJC being so remote and removed, you almost just have to trust the panel as they sat there and waded through all of the evidence and testimonies and all of that. And so I could see why the SJC, I mean, just it's a financial burden. It's difficult in actually dealing with the information. There's a lot of hoops you have to jump through when considering trials at the highest court. Make it difficult.
Yeah, and not even getting into what's the definition of a doctrinal case in public scandal. And we're talking to somebody that there was a long conversation about how do we even define what that is. So, yeah. Right. Well, anything else that we need to say about complaints? Somebody might be listening to this just because they're a clerk in a presbytery or a session, and they're having to handle a complaint, or somebody's thinking about filing one. What should we keep in mind?
I think there's two things just to be thinking about. One, at least as far as matters coming up to the General Assembly, the SJC as the Commission of the General Assembly, I would say complaints are the most frequent matter we get. It's not uncommon for complaints to be dismissed because of time and things like that. So you really need, if you're considering a complaint, you need to know the rules and pay attention to the time. And if you don't know, if you feel uncomfortable with what you're reading, you get help. Even if you call an SJC member, the SJC member will say, I'm not going to talk to you about this. But there are other people that have served on the SJC in the past. Here are a few names. Maybe they'll help you a little bit with it. And just try to have all your ducks in a row. Know why you're complaining, what you're wanting. I think it's wise to make sure it's an important matter. Like we were saying, theoretically, you could complain over the color chosen for a church sanctuary, but those aren't things that are worthy of the time of dealing with. I think in the advancement of the gospel of Christ. So maybe you should leave a few things alone. But anyway, I would read the rules, try to understand the rules.
Yeah, I think everybody will have to have some sort of a struggling in their own hearts and even prayers over submission to the brethren, but then also the glory of God and when to file a complaint. And so finding some pastoral advice on that, I think would also be good just before something like that happens. Well, any final thoughts, Scott or Art?
I don't have anything to add.
Scott?
No, nothing.
All right. Well, first, Art, it's always a delight to see you, and it's even more of a delight whenever I see you at GA and I see your wife, who is probably has the most infectious smile I've ever seen. So
She does.
be sure to say hi to her. And,
I will.
Yeah. And well, I guess as Ben would say if he was here, this podcast is over. You can look into our notes to see some of the notes from this episode. I don't think there will be much, if any, other than looking up some references in Smith who were in Ramsey. But that's all we have for now. So you can say goodbye, gentlemen.
Goodbye.
Goodbye. Thank you very much.
Yes.